Right.
Hello. All right, so we'll get started. And as Hannah said, I will be here throughout the presentation, will be available after everyone has spoken for questions. Okay, so this is a pretty large PowerPoint. We're going to go through the first part pretty quickly because I think the interest, if I remember correctly, is restoration. So we can go ahead and go to the next slide. Okay. And this PowerPoint was just put together with resources of some of our sister agencies. Next slide.
About that, for some reason, it's not letting me. There we go.
Okay. We can skip this slide too. As stated, we're going to try to focus on restoration. Okay. So there's different types of guardianship. Many of you may already be familiar with this. A full guardianship means that your guardian has complete control over your person. That means they make all the decisions about where you live and what you do on a day-to-day basis. You can have a limited guardianship where you have a guardian that only controls a part of your life. Maybe the guardian only oversees your medication, for example, and then you maintain your rights, so your ability to make decisions over everything else. There is a difference between a guardian and a guardian ad litem. Sometimes people get those things confused. A guardian ad litem is an attorney and not a guardian. But there's also a big difference between a guardian ad litem and a court-appointed attorney because the guardian ad litem is not necessarily working for the court, but they are reporting to the court what they think is in your best interest, which may be very different from what you want. Whereas your attorney will be arguing for what you want, regardless of whether they think it's in your best interest or not. That can be a little bit confusing. Um, Next slide. So this just goes into a little bit of history. Don't know that many people would be interested in this, but Missouri just recently in 2018 changed their statutes. The law had previously been written, I think, in the 80s, and so it was quite outdated. And there's been lots of national changes, and Missouri was just trying to update its records to keep pace with some of the progressive movement in the country. Next slide. Sorry, my screen's kind of hard to Okay, so this list here is just some of the things that were updated in the 2018 overhaul of the statutes, where the courts are trying to give priority to a person's family members over a public guardian or the public administrator. And they also recognize co-guardians, whereas in the past, Missouri did not like to appoint more than one guardian in case there was conflict. If there was, not an agreement, they would generally end up back in court, and it kind of posed a burden on the courts to have so many people coming back in just to resolve family issues. And then, of course, respondents' rights. All individuals who have a petition filed against them for guardianship, they have to be notified, and all of their rights are actually codified in the law now, whereas they were not as clear before. Next slide. Okay. This information here just goes into more what happens in court whenever a petition is filed. Um, of course, like any other proceeding, there needs to be proof before a person is placed under guardianship, and that's what the slide talks about. We can move to the next slide. So whenever I spoke earlier about the new statutes that were updated in 2018, including the rights of the ward. This page here actually goes through the rights that were specifically included in the statutes, and this is where you can find them. I don't know if a lot of people know or have experience looking up the statute online, but everything that's in the guardianship code can be found online. And if you just do a Google search and put in, 475361, what's here, you'll be able to pull up the statute and look at these items here. I just want to make sure that I'm correct. I should be going through these quickly. I want to focus more towards the end. Is that correct, on restoration and alternatives to guardianship?
Yeah, I think that's for the most part what our
Okay.
group was mostly interested in.
Okay, so we can move on. We can move to the next slide. Okay. Okay, so now we're starting to move a little bit into alternatives to guardianship, and then I think lastly will be restoration. So before the change in the law in 2018, Missouri did not require that judges look into less restrictive. Well, they had to look into less restrictive means of guardianship. It wasn't as clear in the law, and a lot of judges in the state of Missouri did not focus on least restrictive environment or least restrictive forms of guardianship. But whenever the law was rewritten in 2018, there was information specifically put in the law that required that judges consider whether or not a person truly needs a guardian, regardless of how much help they need. So an individual can have, many impediments and may need a lot of support, but if they're able to get their needs met and they're able to get the support that they need to be independent through the community, whether it be church, family, friends, or even through, state services, then a judge really should not be appointing that individual a guardian. And so what this page is stating is that it's now something that a judge must consider and must address whenever they're entering an order for guardianship, whereas before they did not have to do that. Next page. Again, this just emphasizes some of the new rules that focus on what an individual can do, and the court's obligation to make sure that it fully understands what an individual is capable of before they take the extreme step of appointing a guardian to that individual. Next step. So this is this page here kind of goes over some of the evidence that's required in court whenever a judge is considering a petition for guardianship. Whenever you look at the law, it can be confusing because it seems to be very clear, what needs to happen whenever you go to court and what should happen. But it does vary, between counties in the state of Missouri, and sometimes it varies even within the same county, depending on the judge that you have. So this is, we're starting, the talk about restoration. Whenever a person is placed under a guardianship, they have the right, to request restoration twice a year. So every 6 months, a person can, request the court look at their case, or they can file a request for termination of a conservatorship or restoration of the rights, which would be a termination of the guardianship. And those are two different things. I'm not sure, if the audience understands the difference between a guardian and a conservator. I mentioned earlier, a guardian is the person who makes all the decisions over your person. So what you do on a day-to-day basis, it can, even, touch on what you eat. there's a lot of guardians that control what their wards can eat. But a conservator is a person that's appointed by the court that has control over the person's finances. And many times you'll have a person who has both a guardian and a conservator, but you can have an individual who just has a guardian or just has a conservator or just has a limited guardian and has a limited conservator, or both a limited guardian and limited conservator. So it can be pretty confusing. But regardless of the level of oversight that a person has, these steps for restoration are the same, whether it's for guardianship or for conservatorship. And that always begins with notification to the court. Now, it's easier and a lot of times faster if the person has an attorney, but an individual under guardianship can write a letter to the court telling the court that they think that they're ready for restoration, and the court must act on that. And I see evidence on CaseNet many times, that individuals under guardianship do, advocate for themselves without an attorney, because the letters that they write to the court are actually, they become part of the record and they are posted on CaseNet. And that is a good sign, like I said, that the court is, recognizing the documentation and they're moving on it. So you don't necessarily have to have an attorney and file a formal petition. You can write a letter, or anyone can write a letter on the person's behalf. And normally, whenever a person is seeking restoration, they do have to have some sort of evidence showing that they have regained some or all of their abilities to make their decisions. So if a person is under guardianship of the person, they have to have some sort of medical documentation, and it doesn't necessarily have to be from a medical doctor or a psychiatrist. It can be from a psychologist, and many courts will even consider, letters of support from case managers or therapists. But you have to be able to show that something has occurred, that there's, some event or, lessening of symptoms that demonstrates that the person is now able to make the decisions that the court previously found that they could not make. Guardianship, unlike supported decision making or a power of attorney, always starts in the court, and a guardianship or conservatorship cannot be removed without going back to the court. So it's placed on the person by a judge, and it has to be removed by a judge. Can we see what the next slide is? Okay, so I'll finish this up before I touch on some of the alternatives. The hearing, once the judge receives the petition and or the letter requesting the judge to look into the termination of the conservatorship or the restoration of the rights, which would be an elimination of the guardianship, they need to set a hearing. Now, if the person has a public administrator as their guardian, and the public administrator agrees that they no longer need a guardian, many courts won't even have a hearing. There is a very close relationship between many probate courts and the public administrators, which, if you think about it, it makes sense. The public administrators are in the probate courts on a nearly daily basis. And so, they form friendships and, relationships. And many times the probate courts, the judges, they rely heavily on the public administrator's opinions. And so if a person is lucky enough to have a public administrator who's their guardian, and that person, agrees that it's time for them to no longer have a guardian, the judge a lot of times will just sign off on it and not even require a hearing. Now, if the person wants to be restored and their guardian, whether it's a public administrator or a relative or a friend, whomever their guardian is, if they do not agree, many times the judge will want a hearing. Those hearings can look very different. I've been to guardian restoration hearings that took 10 minutes. I've been to guardian restoration hearings that have taken days, several days. And that's highly unusual. But whether it does take 10 minutes or if it takes days, it's still the same process. The judge is going to want to hear from both sides. The judge is going to want to see what the medical evidence is that supports the restoration, that the person no longer needs a guardian or conservator. And then they may or may not want to hear from witnesses. One of the biggest problems that I'm seeing in Missouri is it's a hardship one to get a medical letter from a doctor or a psychiatrist. And previously, courts would always accept either a written letter from a doctor or a psychiatrist or their deposition. But a lot of times what I'm seeing recently is public administrators or guardians who don't agree with the restoration. They are trying to force the doctors to have to be in court in person. So they're arguing that it's no longer sufficient for the letter or the deposition, that the judge, should require that this person be there, to testify live. And this is a huge burden on a practicing doctor or psychiatrist because they have patients. They work Monday through Friday, 8 a.m., to late in the evening, seeing back-to-back patients, and they cannot, take off from their practice to drive to court, to sit and wait until they're called to testify and then give testimony and then drive back to their practice. At a minimum, it would take 2 hours out of their day. But practically speaking, it would probably take them much longer to get this done. And so doctors and psychiatrists, they don't want to get involved. They don't want to supply letters. They don't want to supply interrogatories or depositions because they're afraid that they're going to get subpoenaed and have to go to court to testify. And so just that little small piece there is making it much more difficult for individuals who are under guardianship to be able to get their rights back. Because doctors who, not in the too distant past, were, very happy to write letters on behalf of their patients, are now not wanting to do that. Again, because they don't want the hassle of being called to testify in court. But moving on, once you have the hearing and the judge decides on what kind of evidence needs to be presented, the judge usually makes a decision right then. I would say more than 90% of the time, as soon as that guardianship hearing is over, the judge will announce his or her decision right then. And if the person is, restored, if the guardian or conservator is removed, they'll get the judgment, they'll get the judge's decision and there will be a judgment, but they're not automatically released from the oversight. It can take 30 or more days for the guardian and or the conservator to kind of wind up their affairs and get everything ready to be turned over to the person. And so the person who has had their rights restored is still waiting, even though they know that the judge has ruled in their favor. They still don't, begin making their own decisions right away. They still a lot of times have to wait a minimum of a month, sometimes as long as 2 months to get out.
I'm
Is that,
wondering,
go ahead.
oh, sorry, I thought we lost you for a minute, but I think you're back now.
Um, But there are things that, we can do proactively now, since the revisions to the guardianship statute in 2018 that really didn't have the same effect prior to 2018. So, there are ways to completely circumvent, a guardianship. And those ways are, through supported decision making documents and or, power of attorney. Whenever a petition is filed, to place someone under guardianship, uh, the judge should ask, and if the judge doesn't ask, it certainly should be brought to the judge's attention that the person has a supported decision making document and or a power of attorney. Um, and there is a difference between the two. Supported decision making is kind of a contract that an individual has with one or multiple people who are going to be providing services or support, to make sure that the individual is able to maintain their independence and live within the community, and just have a life like anyone else would want. Whereas a power of attorney, um, it could be looked at as a contract as well. But usually it's an appointment of a person to make decisions for, the individual. Sometimes the decision making can be immediate. A lot of times under a durable power of attorney, it does not go into effect unless the person has been deemed incapacitated. Uh, Meaning that the person who writes or whoever the power of attorney is for, they continue to make all of their decisions. So the agent or the person who's designated to make decisions, their role is minimal. Whereas in a supported decision making document, the role of the individuals who contract with the person who the SDM is for, it's a very interactive, ongoing relationship. In both of those documents, both the supported decision making and a power of attorney, the individual, with a disability, or a lot of people have these documents, even though they may not have a disability, just to be prepared in case, something should befall them, in the future, and they're ready. But the person, who has these documents, they are in control. They're the ones who can hire and fire, the service providers under this supported decision making. They're the ones who, can express their displeasure and make changes in the types of services, as well as with the service providers. Um, and that's true with the power of attorney. Power of attorney can be a limited document, it could be a broad document, and the person can also change who they want to be their agent at any time. And this is very different, of course, than with the guardianship, because as I mentioned, the individual makes no changes to a guardianship or a conservatorship. That is only done through the court, through a judge. Um, so, with these documents, also too, um, I want to make it clear, just because a person has these documents doesn't mean that a judge will recognize them, or even though, the person has, been functioning under, there's been circumstances where, individuals have had both effective supported decision-making documents and, a very well-drafted power of attorney, and a petition for guardianship has been filed. And even though they have these documents and they have a history demonstrating that the supported decision-making document is effective, for them and meeting their needs, that doesn't mean that the judge is going to accept it and allow the person to continue under those documents. Judges can kind of dismiss these documents and still appoint a guardian for that person, regardless. So I don't want anyone to think that just because they have these documents that they're somehow, safe from ever having a guardian or conservator appointment. Um, I don't know. How are we doing on time? I can't see on my screen.
I think we're good on time. We are right after 5 o'clock, but you're good to keep going.
Well, I think I may be, what's on the next, yeah. So we can go to the next. I've kind of touched on, we can go to the next, all of the supported decision making, the power of attorney documents, um, they're they're based on the person, what that person's needs are, what that person's wants are. We can move on to the next screen. So it's an interactive process, where the individual who needs the documents, of course, they should be involved at every step. And none of the documents should be written without their input or, express involvement. With both of the documents, they do have to be signed and approved by the individual for whom the documents are for. Um, Supported decision making doesn't necessarily have to be signed before a notary. A power of attorney does, but I always advise all my clients when drafting a supported decision making to make sure that they have witnesses and that they do have it notarized and executed in the same way as a power of attorney document. We can move to the next slide. So, and we can move on to the next slide. This slide here and some of these things here, it's always a balancing act. And whenever I mentioned, that an individual who's been successful living in the community with a supported decision-making document, may still find themselves in the predicament of having a guardian appointed to them. It's kind of, whenever you think about the balancing scale that we, just looked at, and then also, the autonomy of the person and the different levels of support. A judge, depending on the judge's background and education and experiences, the judge may be one who wants to protect, rather than allow the individual to have, risk of life. There is a risk for every person in life, whether the person has a disability or not, you know. And I think for a lot of individuals who work with individuals with disabilities, and this includes judges, they don't want to allow, individuals with disabilities any risk. They want to completely insulate them from any negativity or bad mistakes. And it's very strange to me. I don't understand that. But that's what these pages here are referring to. And a lot of times, that is what I see play out in court, both by, the probate court and then the individuals who file or are seeking to have someone placed under guardianship. It's usually always expressed in terms of, needed safety, that the person really needs to be insulated, and they're worried about, their personal safety or their, financial exploitation. We can move on to the next page. But those things too, the risk of life and I think the pervasive need of people in the court system to want to protect individuals with disabilities. That in and of itself makes it much harder for someone who's been placed under guardianship, to become their own person again, to be restored. Because it is a hard burden if a court is expecting, a ward is a person who has a guardian, to come into court, and or their attorney, and be able to prove, to the court without a doubt that this person is at no risk if they no longer have a guardian and, conservator. Like I said, it's a very heavy burden because everyone's at risk every day. Yeah. Let's see. So this slide, and I think a few of the subsequent slides, is um, a lot of there's there's a lot of belief out there that if an individual has a certain diagnosis, then they automatically need a guardian. And this is a pervasive belief, especially for individuals with intellectual disabilities. Um, you know, intellectual disabilities can be mild, they can be severe. But for some reason, a lot of individuals who are associated with the courts or in the court system, whenever they hear that someone has an intellectual disability, it triggers something in their mind where they think, well, that person automatically needs a guardian. And for mental illness, schizophrenia seems to be that trigger. And it's not true. There's, every individual out there who has an intellectual disability does not have a guardian, does not need a guardian. Now, are there some, there may be, but again, there's something that, switches, and people tend to want to seek guardianship whenever they see an ID diagnosis, and the same for, mental illness whenever they see, schizophrenia diagnosed. We can go to the next slide. Yeah, so this just kind of circles back to what I was saying at the beginning. I'm sure that most people on this call are aware of how suffocating, a full guardianship can be. Um, the guardian truly does make every decision, for their ward. Now, even though even though a person may have a full guardianship, if they're lucky enough to have a family member who's been appointed their guardian, um, the family member can allow that person as much freedom as they think is reasonable. Um, but a person who's under a full guardianship and is unlucky, in some instances to have a public administrator, they usually have no freedoms. Public administrators, and I'm not here to bash public administrators. There's actually quite a few really good public administrators in the state of Missouri. Our agency works with a lot of public administrators. They actually seek our assistance, for helping their wards get Social Security or even restoration. And that happened not too long ago in a case that I had in Callaway County with Karen Allen. So, public administrators, like any other profession, you have some that are good and some that are bad, just like you have some good attorneys, you have some bad attorneys. But public administrators are burdened. They have a lot of wards and a lot of times not enough staff, and they are, responsible for the safety of their wards, and they're required to see them. They only have to see them once a year. But, if you're in a county and there's only two people in your office and you have 500 wards, and you have to see them at least once a year, you can, only truly be expected to see them once a year. There's just not a time, enough time in the year, to see that many people. But if you are, responsible for their safety, and well-being, then, how do you make sure that happens? And the answer for a lot of public administrators is, placement in a nursing home or some other facility that provides 24-hour oversight. And that's why, in Missouri, we see so many people who are in these really restrictive environments because they're, guardians, the public administrators. I don't think it's done, to be mean-spirited. It's just they have a huge burden to make sure that, their wards are safe, and they don't have enough time or personnel, to do that personally. And so they have to rely on these third parties and these facilities to make sure that their wards are safe. And go to the next slide. And we've been talking about supported decision making. We can go to the next slide. Yeah. And, again, all of the things that anyone would do, on their day-to-day life, can be addressed in a supported decision-making document or in a power of attorney document. These things that are listed here, a lot of times I use those as examples because um, what I see in court is, a lot of times witnesses and or evidence will be presented by the side who wants the guardianship, and they always say, well, this person, they don't know how to make this decision or they don't know how to do this, and they have to ask for help, with whatever, items they list. But, we all do that. I do that. Um, I do not know how to fix my car. If something goes wrong with my car, I have to ask somebody. I might start with my husband, but ultimately we'll probably end up in a mechanic. We go to someone. So it's to me, it's just a little bit of a double standard, but also discrimination because everyone, needs help with something. And it doesn't matter how smart you are or how many degrees you have, you can't know everything. And whenever you don't know something, the smart, responsible thing is to ask. And in many ways, individuals with disabilities, they get punished, for doing the very thing that we all do, by asking questions and seeking help. It's somehow turned against them and used as support, to demonstrate why they need a guardian. We can go to the next slide. And again, we've been talking about this, but a supported decision-making document, if done correctly, um, should be able to, keep a person out of the courts and off of guardianship. But as I've stated, even though the law requires that a judge look at a supported decision-making document and ask questions to see how well it's working, if there's been any issues, even if it's been shown that it does work and there's not been issues, the judge does not have to accept it. The judge can still appoint a guardian. We can move to the next. And then just some quotes and general statements that I think we all know that, the more control a person has over themselves, and their, decision making, the happier they are. Goes for all of us, that's not something that's limited to individuals with disabilities. I think we're all happier the more control we have over our lives. Next slide. Next slide. And I think if I'm remembering correctly, I think the rest of this PowerPoint pretty much touches on supported decision making. It is a team effort, as I said, but the individual, for whom the document supports is always the person, in charge. And of course, I think we all know, even though the person is in charge, with some of the challenges we have in the state with housing and PCAs and being able to access personnel and, be able to pay a competitive wage. Sometimes it doesn't feel like they do have those choices. They may not want to be working with someone, but they may not have a choice because there's just literally no one else to hire. We can move to the next slide. We move to the next slide. Should I continue to talk about alternatives, or do we want to move on to the
I
other
think we,
speakers and then have more time at the end? Because I've seen some hands. I think I might have a lot of questions at the end.
yeah, you probably will. I've seen some hands as well. And the other presentation is pretty short. So if you if you want, I think you could probably wrap up this topic in the next 5 or so minutes if you want to just kind of briefly summarize supported decision making, and then we'll go to the panelists briefly. They won't take very long, and I think we'll still have plenty of time for questions.
Okay. Um, So, supported decision making, just yeah, try to um, go over all the things I've been touching on. There's no required document in the state of Missouri. Supported decision making, in Missouri can look many ways, just like a power of attorney can look many ways. But if you do go on Google, you can find some good examples of supported decision making documents that have been used in Missouri, as well as power of attorney. In fact, the Missouri Bar, if you Google the Missouri Bar power of attorney, supported decision making, you can pull up some forms, especially their power of attorney. It's really good. Um, and it's one that you can just kind of fill in the blanks. And it does go through, how to execute the document and what needs to be done. Um, with the supported decision making, whatever, format you have for that or a power of attorney, um, to to make it as effective as possible, you want to make sure as many people as possible know that you have the document. So of course, once it's completed, whether it's a supported decision making and or a power of attorney, once it's completed, you want to make sure that, of course, all of the people on your team have a copy. You want to make sure that all of your friends and family have a copy. The people who are involved in your life, you want to make sure that they know what you're doing, how it's working, and what the agreements look like. If you have, you know, supported decision making where you've contracted with a specific provider, of course, the person who's providing the services is going to be involved, but you want to make sure that all of this information is kept within your file with them as well. With the power of attorney, it's very important to make sure, especially if it has anything to do with medical care, um, that you've provided a copy to your doctor. Anyone who provides any sort of medical services, also you want to have a copy on file with your local hospital. And the reason that's important is if you have an emergency and you show up at the hospital with your power of attorney, or your agent shows up with power of attorney and the hospital has not seen it, or your medical provider has not seen it, it is possible that they could refuse to recognize it. There are some things that can be designated in a power of attorney that uh, a doctor does not have to follow. So, for instance, if someone puts in their power of attorney that, a do not resuscitate order, and a doctor does not want to follow that, under Missouri law, they don't have to. But if you provide it to them beforehand, then they have to tell you beforehand. So that's why you should make sure, that your documents are in the hands of the people who need them, so that before you have an emergency or need the documents that everyone's in agreement and that they will follow your wishes. Um, So this could kind of be tied into the restoration piece too. We talked about how these documents can help possibly keep a person off of guardianship when a petition is filed, but these documents could also be used for restoration purposes too. So, once the court's been notified by a petition or a letter that a person is interested in seeking restoration, they could ask the court's permission, to let them try out a supported decision-making document. They could present the court, with a draft supported decision-making document, with where the person plans to live, who they plan to get services from, and demonstrate that the service providers are in agreement and that they can and they will provide the services, et cetera, et cetera. And I have seen, not many, but I have seen a couple judges allow that, on temporary basis, where the judge will say, okay, we can do a trial run on this drafted supported decision-making document, and then we'll come back in 4 to 6 months and see how it's going. And if it's going great, then that's just more evidence in support of the restoration or the removal of the guardianship. So these documents are important, before guardianship, but possibly during, and even after. There's a lot of times whenever people have been restored, particularly individuals who have mental illness, there's always a fear that there may be a disruption with their medication. But if you have a supported decision-making and or a power of attorney document that's in effect after restoration, if there is any sort of relapse, it can easily be dealt with without having to go back to the courts. It would be addressed within those documents, and then the people who have contracted or have agreed to be agents, they would just, kind of pick it up and know where to go. Well, I'm trying to think of anything I might have missed as far as restoration and alternatives. And there are some other alternatives that have more to do with conservatorship, but I don't know that necessarily needed. Do you want me to talk about that? Most of it has to do with Social Security and representative payees and how they can be an alternative to a conservator. Um, but again, you can bypass a conservator with supported decision making and with the power of attorney for finances too.
Do you want me to scroll through and see if there's a slide on?
Yeah,
Okay, let me see.
yeah, we can move
Oh,
forward.
okay, here we go.
Oh, so I don't know if anybody wants a copy of this PowerPoint. I don't know if my email is posted, but I can certainly share it. We can move to the next slide because I think there are a couple of examples of power of attorney, and there might be a couple of examples of supported decision making. Um, and then also, we've gone through this quickly and also not as smoothly as I normally would, trying to focus on a couple of areas specifically. So if anyone would just want this, to be able to refer to, like I said, I'm happy to share. We can move on and move on. Mm. So it looks like towards the end, I just have more of the law, some of the statutes where you can find the specific requirements for power of attorney. But again, they can be handwritten, they can be typed. Um, there's no specific way that they, have to be formatted. You just have to make sure that um, the individual's signature is notarized. They have two witnesses' signatures that are notarized in order for it to have full effective law. And we can move to the next one. And then just some things that you can't do with the power of attorney. And
All right, looks like we've made it to the end.
all right, thank you.